Welcome, everyone, and happy Tuesday. Thank you for joining us for the new way of conducting patent research, proven strategies for efficient due diligence, presented by Paralegal Brief and sponsored by Mindsoft. I'm Tori, the webinar coordinator of Paralegal Brief, and I'm excited to bring you this session with best practices in researching and producing thorough patent due diligence reports. I'm looking forward to hearing from Andrew Klein and Jennifer Vandenplas in what I'm sure will be an informative presentation. In case you miss any part of today's webinar, we will be recording this session and emailing it to you within the next 48 hours. You can also go to the registration page to access the recording. We're going to be sending that link over to you in the chat right now. Up next, we'd like to encourage you all to participate in the poll on your screen. As you submit your responses, I want to thank Mindsoft for sponsoring this series and helping us to make it happen. Mindsoft is a global leader in AI-powered patent intelligence, helping businesses, law firms, and IP professionals streamline workflows and make informed decisions with confidence. Their advanced solutions simplify patent search, analysis, and monitoring, transforming complex data into actionable insights. Trusted by over 120,000 users worldwide, including 8 of the top 10 law firms and 18 of the top 20 pharmaceutical companies. Mindsoft combines cutting-edge technology with unparalleled expertise to support innovation. With over 20 years of refining patent data, a people-first approach, and a commitment to quality and reliability, Mindsoft is the go-to partner for organizations looking to harness the power of IP intelligence. So thanks again, Mindsoft. Up next. Let's quickly get some technical things out of the way. Don't hesitate to send in your questions throughout today's presentation for the Q&A session with our panelists at the end of the hour. You can do so by submitting your questions into the Q&A panel found in the bottom toolbar of this webinar window. The chat is also available for open discussion. Be sure to change the blue button in the chat box from host and panelists to everyone so that you can join the conversation. My wonderful colleague Tara will be here to field your questions, and she's happy to answer anything technical you might have. So feel free to pull up the chat to say hello and let her know where you're joining us from. Closed captioning is available. To enable this feature, select the More button in the bottom toolbar and select the Show Captions option. Lastly, if you have any audio issues during today's presentation, you may choose to dial in by phone. All dial-in information can be found in your confirmation email from Zoom, and Tara can relay that to you at any point if you need it. Up next. Again, today I'm excited to hear from our two amazing panelists, Andrew Klein, Principal Solutions Consultant at Mindsoft, and Jennifer Vandenplas, IP International Resource and Training Manager at Foley and Lardner LLP. So without further ado, I'm going to pass it over to our speakers.
Thanks, Tori, and hi, everybody. My name's Andrew. As Tori said, I'm joined by Jennifer from Foley and Lardner, and we're here to tell you a little bit more about doing due diligence in the context of doing patent research. So thanks for joining us. Let's review the agenda briefly. We're going to talk at a high level about what due diligence means in the context, once again, of patent research. So the what of due diligence, more importantly, perhaps the why somebody would do a due diligence project. And then we'll get into the interesting part, of course, which is how to go about it. And specifically, how paralegals play a role in this very important process that many law firms help their clients out with. So we'll address the paralegal's role and some questions for them to ask if they get involved with projects like this. And then we're going to take you step by step through the process of doing a due diligence project and producing a report that can then be forwarded on to the attorney you're working with or eventually to the clients to help them make the decisions that they want to make. For those actions along the way, we're going to highlight some pain points that Jennifer and I know that folks doing this work run into from time to time, and some best practices that you can use to try to alleviate those pain points. We'll also at the end address some common pitfalls. So these are things that that can frequently create problems or introduce difficulties in producing a report. So we'll address those, give you a heads up as to what to look for, and once again, best practices for getting around them. So starting at the top, If you have never heard the term due diligence when it comes to patent research before, and by the way, for the sake of this presentation, we're focusing on patent portfolios only. You can certainly do due diligence on other portfolios, trademark or copyright or domain name portfolios, but Jennifer and I work exclusively in the area of patent information, so that's the scope of our presentation today. Patent due diligence is a close review of a patent portfolio to confirm and verify key information. And that key information is the scope of the assets. So in specific, where are they filed? How many are they when it comes to foreign filings, or the size of family members? And then the legal status of that portfolio. So hopefully many of you know that a patent is, of course, the legal right to exclude somebody else from practicing or selling an invention. And that legal right is only enforceable when the patent itself is still valid. So figuring out things like whether it's a pending application versus a granted patent, about whether it's alive versus expired or withdrawn, and when that expiry will happen, a very important aspect to understanding the scope and the strength of a patent portfolio. Finally, the property part of IP, intellectual property, of course, relates to ownership. And if you don't have correct ownership for your intellectual property, is it really your intellectual property? I would argue no. So that's going to be an important point to discover as well. Why do companies and the law firms that support those companies do due diligence projects? I like to think about this in terms of two quadrants, one of them having to do with offensive versus defensive, where the offensive would be that your client is interested in taking action with something regarding either their portfolio or the portfolio of another company. So, for example, if it's a portfolio of another company, perhaps they plan to purchase part of that portfolio or the company as a whole. Uh, if it's their own portfolio, maybe they are looking for a specific patent or a group of patents that they wish to monetize in some way. So out licensing, for instance, they would like to identify potential licensing partners with whom they can make a deal. On the other side is the defensive side. So this might be done in anticipation of being on the other side of a deal like this, where the client plans to sell a portfolio or has sights on being acquired, or from a licensing point of view, they're interested in licensing their own portfolio and finding someone to pay them for the rights for their IP. I would say that this sort around mergers and acquisitions or licensing is one of the most common reasons why due diligence takes place. It's not the only reason, however. There are also use cases that have to do with strategic IP counseling. So if your attorney is counseling your law firm on common IP needs, like for instance, the freedom to operate, or whether or not a patent is valid or enforceable, known as a validity opinion. Validity might happen in response to an assertion. In other words, your client um, it has received, for instance, a cease and desist letter from a competitor of theirs telling them, you can't do that, you're stepping on our patent rights. At which point they would consider, well, am I really, if that patent is no longer valid? So that might be a good reason to do this work. Also, once again, on the defensive side, almost like play testing their own portfolio for future assessment or enforcement, so they don't find themselves on the surprise end of that same action of having someone they wish to assert their patent rights against come back and say, actually, I don't think your portfolio is defensible either. So this sort of due diligence project will involve quite a bit of analysis of the text of the patents themselves, known as the claims, the legally important part of the patent, to analyze whether they fall within the scope of a product for a freedom to operate analysis, and taking a close look at whether or not those claims are in fact novel for a validity analysis. So those are some of the more common reasons for doing a due diligence project. So when due diligence is done, what are the overall steps for doing that? So if you are taking a deep dive into a patent portfolio, the first thing you need to understand is, what does that portfolio constitute? What specific assets are in play? So the most common places to start for this project are for a list of assets to be provided. In other words, a list of patent or application numbers. In other cases, you may be told we need to do due diligence on company X's portfolio, on anything that is owned by that company, in which case you would start with a search based on that company or entity name. For example, based on an assignee name or on vendor searches. So that's step one, run the search. Next, reports are generated with that relevant data. So the initial search is run, more work is done to perhaps expand the scope of that search to capture other relevant data. Once that first draft of a report is ready, then the actual due diligence, which is an asset by asset review and confirmation of that data, takes place. And then issues, any problems or any red flags that may be identified along the way will also be noted. So if you've never been involved with a due diligence project, probably that's why you're here attending this webinar. If so, thanks much. If you haven't, this might be an interesting thing to consider as well. But what would your role be, assuming you are a paralegal, in doing this sort of project? Oftentimes, when I have worked with folks doing this work using our products, they are doing it on behalf of somebody else within your firm, perhaps the attorney you're working with or directly with the client. So you are doing this on behalf of someone who's eventually going to be using this data to do this analysis. Your role, therefore, is primarily to enable that IP counsel to complete their analysis. So in order to help them do that, some things that you need to keep in mind is being able to understand the scope. So as I mentioned before, what exactly are we doing due diligence on here? You also need to understand what data is required. So is this a case where there is a deep analysis of the claims or not? And then finally, you are going to be producing that report upon which the rest of this process takes place. So let's get into some questions for you to ask right away before getting involved with this process. So first of all, where am I starting? What is that search going to be? Has the client provided a list of assets? This is sometimes called a disclosure schedule. So this would then constitute a starting place for you to run that search based on numbers within that list of assets. Um, or perhaps this is a case where the client has not gotten involved yet, and instead the attorney is doing this defensively, in order to perhaps discuss with the client some of these strategic reasons. So maybe the attorney is just going to say, hey, go and do this, and here's the list of assets. Without a list of assets, of course, you need something else. Oftentimes, that is a company name. Uh, when you are doing a company search, you'll want to ask about possible subsidiaries or affiliates. Many large organizations may be filing their patents under a variety of names. So knowing the scope of is it just company name X? Is that all? Or are there variations I should include too? So where to start, the scope of the data, and then what data is going to be required. Sometimes for projects like this, it may be US centric. You may only be looking at a US portfolio. In other cases, you might be wanting to include foreign filings as well. So understanding whether, the portfolio in their terms means US only or global filings important to know. And then also the scope of the assets being analyzed. Is this the whole portfolio? Is this a section of it? Is it active grants only? Sometimes when people talk about patent portfolios, they are excluding pending applications or expired or withdrawn patents. In some cases, they're not. So at a high level, this will help uncover the additional details you will need to do an effective search and gather the data right away. The yeah,
Andrew,
yeah,
oh,
go
I'm
ahead,
sorry.
Jennifer.
Yeah,
Yes,
I just wanted to jump in on
please.
some of the first items, like where you're
Uh-huh.
starting, and in particular the disclosure schedule.
Sure.
Oftentimes, when a company is putting forth their patent assets for sale, they will give a disclosure schedule. Now, we never take that at face value as being
Mm,
everything that they have. And so we will always do independent searches when a third party is providing the schedule. Likewise, if our client is putting their certain assets up for sale or a subsidiary, we always do a comprehensive search and then compare it to what the disclosure schedule is, what the seller says they own, and then also maybe what a client believes they own to identify any
sure.
issues they might have with the purchase or the sale.
Great. That's a great clarification, Jennifer, and helps really, I think, illuminate why these processes take place. Is, this is, as we said, a due diligence and understanding, both from the client's point of view and also from the law firm's point of view, where exactly, where the scope is and what questions lie waiting to be answered about it is indeed an important point of this. And Jennifer, I'll ask for your further advice, please, on how deep the dive there is to do in this work. And I'm just going to skip over the second version of that slide that kind of snuck in here and go to, I think, some of the ways that you tend to scope out projects like this. So over to you.
Yes, certainly. I'm happy to be here, and thanks, Andrew, for helping to coordinate this. Scope is so important for many reasons before you actually get into the nitty-gritty of the work. Understanding if you're just doing a very shallow look, a preliminary sneak peek, you want to see what a competitor owns, or to get a sense of the technology in general. You might just do a quick search just to get a very high level view. They're only in the US, they're in these countries, the patents are older, younger, whatever that is. You could have an asset of purchase agreement where there's a discrete list of assets. Typically with these asset purchase agreements, that's where we want to look more nitty gritty at asset per asset to make sure what's viable within a portfolio. For stock purchase agreements, the buyer gets everything in the company. And so it doesn't necessarily matter what is going on with the patents, like where they have patent protection, where they might have expirations coming up soon, for example, because they're going to get everything. And so with stock purchase agreements, we're generally interested in litigation. Has this portfolio, this client been marked as infringing someone else's patent? So stock purchase, we don't care as much about the nitty gritty because again, they're going to get everything. It's just part typically of a much larger deal. And we just want to highlight those issues that could cause a pain point for the acquirer. Sometimes it's like the IP makes or breaks a deal. I had worked on a due diligence years ago. It involved several thousand patents, but there was one family that included about 20 patents that was the heart of the entire deal. Without those key patents, the purchaser didn't want anything to go through. And so when we looked at that project, because scope is always important, if you are looking at every little bit of data, it can take a considerable amount of time to go through every asset. You always have a budget. You always have a timetable to meet. So knowing where you want to focus, if it's on every asset, if it's just a very high level view, or general sense of the portfolio, but really crack down on these key patents. So good to know upfront. One thing that we've started to do internally is to create a checklist. Sometimes people don't know what they're asking for. And so someone might say, oh, give me a high level view, just give me status and ownership. And then you finish that, and then they come back and say, oh, can you also get me this bit of data? Well, not knowing that you are going to have to comb through asset by asset by asset again. So what we found is putting together a standard checklist of, do you want status? Do you want ownership? Do you want to know about terminal disclaimers? Is patent term important? Are you concerned about any kind of petitions, et cetera, that we'll go into in a little while? So determining that scope will help you keep within your budget for time and cost. It will also save you time because my practice, you touch each asset once and only once. You don't want to have to circle back. So efficiency is important. Knowing the scope is important at the very, very beginning.
Sure, sure. Sounds like an ounce of prevention in this case is
Yes.
the proverbial pound of cure. Excellent. Thanks, Jennifer. So let's get into that, the process itself that the proper scoping will help keep efficient as we go along. As you can see, there's, quite a few steps here, and each one of those kind of belies further detail underneath. So let's start with the part that here at Mindsoft we're quite frequently helping folks with, which is patent searching, conducting the search. So as I mentioned before, oftentimes you will be starting from a list of assets, whether that's, as Jennifer said, the disclosure statement, which then forms the starting place, certainly not the ending place, but the starting place for a search, or a list that's been perhaps provided to you by an attorney. At first glance, this might seem straightforward. Got a list of numbers, go into, a tool of some kind, put those numbers in, and then, retrieve information about that specific patent. But first of all, if the scope of your due diligence encompasses many, many jurisdictions, it may be that you would need to go to, the USPTO website first, and then the European Patent Office website next, and then WIPO for PCT filings. So multiple resources to capture all jurisdictions could quickly get painful for you. How about formatting inconsistencies? Maybe, a US patent number is formatted one way and then further down in the list is formatted another way. Are the tools you're going to have balk at, logistical issues of dealing with data like this? And how about missing documents? Let's say you run a search like this and, everything that came from a particular jurisdiction, Brazil, for instance, just doesn't appear because, the tool you're using didn't find that data. So what are some best practices? Hold on just a moment. Let's see here. Um, the best practices are coming with the next slide. Sorry about that, folks. I'm getting a little bit ahead of myself. Okay, so those are some pain points that come along with publication number searches. As I mentioned, the other common place to start would be an assignee search instead. So go find for me everything on record that belongs to company X. Once again, the same issue. If company X files for their patents in the US, yes, you can go and search at the USPTO website for patents that belong to them. But how about those same patents at the European Patent Office or other jurisdictions worldwide? It's going to be painful for you to do each one of those one by one. Also, the so-called assignee data in the patent literature is in no way standardized. Whatever is on the form when you file for a patent application is what then is on record. So what about misspellings or typos or problems transliterating company names from other languages into English, or slight changes in how the company name is listed? For example, abbreviating an incorporated or a company at the end. Are you prepared to capture all of those variations using a manual search? How about foreign subsidiaries that might have slight variations of names? And then possibly the most complicated aspect, what if the company you're looking for has acquired other companies and other patent portfolios, either in the recent past or in the distant past, and never updated those assignment records, so they're still listed under those old names? How can you find those name changes associated with mergers and acquisitions?
And Andrew, just again to reinforce, it's getting the scope of the project. I think identifying your target
Mm-hmm.
and clearly understanding the corporate chain of title and what things are included, looking at those press releases, seeing these mergers and acquisitions that have happened is really important at the front step, because we've done due diligence where we think we know the target, and
Mm-hmm.
then we're reviewing chain of title, possibly in the US, and we say, oh, this name change happened 10 years ago. We didn't
Sure.
search for the previous name. And so those things can make you circle back and start again to supplement the data.
Gotcha. So there are cases when you might just be like, a couple of steps in and suddenly realize based on what you found that you need to go back to the start. Is that right?
Yes, exactly.
All right. And then, so for those of you who are not familiar with what I mean here by incorporating additional hits from family data. So, as I said earlier, a patent right is a national right, the right to exclude somebody else from practicing your invention. And it's based on the jurisdiction that you file in. So many companies file for their patents around the world, and those patents become linked together in what folks like Jennifer and I call a patent family. So getting an understanding of what the members are within any given patent family, really an essential part to doing this work. Once again, some of the same pain points come up, being able to understand what the details are in those multiple jurisdictions worldwide. How about a simple family versus an extended family? There are two common definitions of what a patent family entails, and one might, encompass other things. How about unpublished cases where there is, a patent family member that claims that might be related, but there was never any publication for that? And how do you organize this all so that it makes sense both in your report and for the people who are doing this work and reviewing it later? So, best practices for getting around some of these pain points include um, a vendor supply database. So Many vendor supply databases will have global coverage of patent publications. Doing a single search on a company name will return to you references assigned to that company from dozens of jurisdictions worldwide. So no worries about hopping from patent office to accomplish that. Oftentimes, these databases will also link these patents together for you in terms of those family relationships via, unique identifiers for the patent family. Or in some cases, you'll find nifty visualizations that help you understand a family tree in terms of a way not only that you can understand, but also your client might use to kind of investigate the details too. Now, for that assignee search, oftentimes these tools will come with corporate hierarchies to help you capture those subsidiaries, affiliates, name variations. Once again, you'll be able to start with a company name, easily review a list of those possibilities, and select whether those should be within the scope for your search as well. Next, I'm going to turn this over to Jennifer to show you an example of how she builds out, especially the documents that might be related to one another in terms of family relationships. So Jennifer, back over to you.
Okay, yeah, thanks, Andrew. So whether you conduct the patent searches yourself or they're done for you, it's really important to know what the limitation of the data is that's coming back. This slide is intended to show, so this is if I did a straight asset name search. I'm searching for assets that are in the name of a particular company. It will only bring back assets for which the target is listed on the patent publication, the publication of the application, the publication of the patent, or some subsequent publication. If an asset was assigned to the target after publication, it would not show up in this type of search. This search is only hitting those assets for which the target was identified on the publication. So if we take a look, so when we do this search, I always expand by family. And this is because, typically assets are assigned by family. It's an unusual case where somebody might only assign the EP to one company, the Chinese patents to another, the US to a third, something like that. So first I do the search to identify the target hits, then I expand by family to pick up these additional assets that maybe had a former name on the publication or was a portfolio that was acquired, or maybe they had filed in the name of the inventors for some reason. So again, pulling back those related assets. Now, there are two commercial families that sometimes get thrown around. One is the Impodoc family. That is that extended family. eSpaceNet, if you're familiar with that, or eSpace, that will pull back generally the Impodoc family, the expanded family, which would include CIPs and the like. So we always expand by Impodoc family, and then the Derwent family is the simple family, or the identical counterparts. They have an identical priority. Impodoc and Derwent are both examples of global patent databases, but they get their feeds from different offices at different times, and they don't have 100% overlapping coverage. And so as you can see in this slide, we did the Derwent search. It did not identify the Hong Kong or the Mexican assets. And so by doing the Derwent search and laying that on top of what we've already found, that gives us those additional hits. Next are, as Andrew had alluded to and mentioned before, those unpublished assets. So these can be US provisional applications. Commercial searches will generally only pick up published applications. There are some that go a little deeper, but generally they're only coming back with publications. So it's going to miss those unpublished priority applications, those provisionals. Recently filed continuations in the US, cons, divs, CIPs, filed and are available through PatentScope, but not yet available for review because they have not yet been published, so not picked up in the commercial searches. Lastly, we have those EP validations. A European patent grants, it needs to be validated in the countries of interest in order to take force. Most EP validation countries do not publish, and so you will not find these identified necessarily in your commercial searches.
Thanks, Jennifer. Once you've conducted the search and gone through and solved some of the problems we identified and the pain points and found your way around that, you'll be putting together an initial draft of a report. This report is going to be the first place where you will start arranging all of the information needed for doing due diligence. As I said before, the purpose of due diligence is to verify the scope of the data. So we talked a little bit about that in running the search. And then it's going to be things like legal status and ownership. So uh, as we mentioned before, in kind of determining the scope of this, for some folks, what legal status means will vary from person to person. For some folks, it might literally just be, hey, tell me whether or not, this is either a patented case or a pending application as on file at the PTO. But in many cases, it's going to need to go deeper than that. It might require a review of relevant legal status events. It might require a review for WO, so-called PCT filings, how many places they've gone to national phase with that application. For EP patents, if there's a grant, where is that grant validated and still in force? Since legal status is closely tied to the patent term expiration date, you may be interested in data, for example, around patent term adjustments. Terminal disclaimers fall into that as well. Other PTO-specific data might be important for you to grab too. Around the ownership side, you'll need as much data as possible around, no surprise, who owns the patent, who it's been assigned to, who applied for it. And then some jurisdictions will make updates to that assignment, most notably here in the US, where the US Patent and Trademark Office maintains a separate database of assignment data, which is a very frequent feature of this sort of work. Finally, file history or office action documents that may have bearing, once again, on both of these matters will highlight some important specific documents that you'll want to look for within that. So gathering all of that data for an initial report is going to be the next step in your process.
Yeah. Andrew, I just wanted to make one quick note about INPADOC data. This is a legal status that you find, for example, on eSpace again, or if you run an INPADOC patent family or a patent report and pull out the legal status. One thing to keep in mind is that legal status is only the last update provided by the national office. That legal status is not necessarily definitive. If something shows that a request for examination was filed last month, pretty good indication that it's still an active case. If it says a response to an office action was filed 2 years ago, that does not mean the case is still pending. So INPADOC legal status, while you can find some definitive answers, you might need to investigate further by going to the national PTO databases, which is the source of all the INPADOC data, to verify who is the true owner, what is the true status.
That's right. So the national patent offices kind of pick and choose what they report to INPADOC, which I think is probably the cause of the issue you mentioned, right, Jennifer, that there might be something that they didn't report or didn't report it in a timely way.
Mhm.
Okay, excellent. So once again, pain points, just as we were talking about. So in some places, it's going to be easy for you to come by this data. So INPADOC legal status data is federated in a variety of resources beyond ESPASnet, perhaps in vendor supply databases or Google Patents or other places you use as well. But what about those national patent offices where you do need to go and verify the information that you find there? For some of the things we mentioned, like those file history documents or data about patent term adjustments, those are generally only going to be found in the registry or the Gazette for a particular PTO, unless once again, you're using some of the resource with which to do it. And so once again, we have to recommend that as a best practice. Many vendor supplied resources are going to do some of the work to gather and format this data for you. Oftentimes, the final form of a report like this will be a spreadsheet of some kind, oftentimes Microsoft Excel format, and some vendor supplied resources can give you a head start with that report by configuring an export out of their resource to supply you with much of the data that's being asked for here, including links out to places like PTO registries and nicely formatted US assignment data too. So any comments to make on these best practices, Jennifer?
Yeah, it can't be overstated that you should never start from scratch to create your patent data report. Besides having typographical errors, the time to put something like that together is not worth it. There are a lot of vendors, like Andrew said, that can provide you with the bibliographic data. They do it in a very nice format. You can get export on a lot of things, sometimes links to terminal disclaimers, PTA information, assignment information, all bundled up. You still have to vet it. You still have to do the due diligence, but it is an excellent starting space. And you should always, always, always start with a vendor product.
Okay, let's start stepping through the process of doing the asset review, which is the real work of due diligence to take all of the data that you found from your search and from your gathering and start to make determinations as to the legal status and ownership of these patents. So how do you go about doing this? First of all, as we mentioned before, in some cases, it will literally just be, hey, can you tell me, is this pending? Is this granted? Is this so-called alive or dead? And we use that term as a shorthand for, is it still legally in force for the person who owns it? Could they assert their patent rights or not within the bounds of the law? And for the most part, that just has to do with whether or not the patent term, as I said, is either pending or granted, and whether or not it's expired. So is it within the term that's been granted? So that is going to necessitate a close look at things like patent term adjustments or extensions, which might change that date. And for the US, there's a legal maneuver called a terminal disclaimer, which will affect that, and we'll go into detail about that too. For, as I said earlier, for WO, PCT filings, and EPs, there are a few things specifically about that that will affect the status of those related documents that you'll want to check for in detail as well. On the ownership side, ensuring that the applicant is on record as the applicant is supposed to be, whether or not there's been any change to that ownership. Intellectual property, like any property, can be bought and sold. So has there been some sort of change or reassignment to that data? Something important to check. And then has there been any encumbrance? So it may be that there's a lien or a security interest that is related to that. So we'll need to verify that information as well. Going one by one, reviewing all the relevant data, I can imagine, having never actually done this process myself, that it involves a significant amount of clicking through, chasing down loose ends, finding a fact, maybe updating your report based on what you found, repeating the process over and over and over again, especially if this asset, if this list of assets is quite large, sometimes in hundreds or thousands of patents. So what are some best practices we can do to help you do this review as efficiently as Jennifer said, ideally looking an asset only once and never coming back to it? So as much data in your single report as possible. So yes, it might be easy for you to say, well, I'm just going to have a link out to the US assignment database so that we can check this. But what if you could surface all of the relevant data provided by the US assignment database in your report so people can just scroll and look through and come to a conclusion quickly? So the formatting matters when it comes to gathering this data and organizing it in one place. Now, that won't be the case all the time. Sometimes there's no way to include that, so you will have to link out directly. But if there are places where you can derive this data, so perhaps there's some fancy processing that a vendor website or a vendor tool has done to highlight some of these problems for you. You should definitely make use of that to your advantage as much as you can. One case in point, as I said, US assignment data can be an essential part of this. And Jennifer knows this well and is going to walk us a little bit through how she organizes this data when she is doing this work. So back to you, Jennifer.
Yes, thanks. Before I jump specifically into the assignment database, I did want to talk about some best practices with respect to the patent data report. So this is that report is generated by your vendor, and then you start to supplement it with additional information and your findings. We always use Excel. vendors, whether they're public or private, they will have an export in Excel. And we find that that is the most suitable format for these projects. It allows you to sort things. Like Andrew said, sometimes you have to go asset by asset before national PTO to sort by all US cases, and all US cases by family. Identifier is going to be very, very helpful for you. If you're not versed in Excel, it's worthwhile getting versed in Excel. I had somebody prepare a very comprehensive summary for me. He sent me the data. I immediately sorted it to look like I needed it to look to understand it. And he had done line numbers, not thinking anyone would touch the data. So his line numbers were gone. Not so great.
Oops.
One cell per data field, status, ownership, etc. Put those in its own cell because, again, you will sort. You might pivot the information out to make it more useful. Keep those in individual cells. Don't combine them. Likewise, one line per asset. So if you have a Chinese case, that is one line. Don't group all of the family members at the end. Sometimes these databases will have all publications, and so you'll have duplicates and not know it. Each asset, as Andrew mentioned, is its own divisible right that can be disposed of or acquired on its own. And each will have its own individual issues or data. So that goes for EP validations as well. We always break out EP validations. We give them a country code EP/country, so we know it's an EP validation. That will help the attorney know that they don't need to review the claims if they know the EP claims. Keeps all of that information together. Empty fields are ambiguous. So it's a checkbox or an X. We always, if you're looking at data, put a yes or a no if it's that simple. Don't just put an X if it's a yes, because nobody's going to know what that means later. Likewise with color. I have I have some resistance to using color in spreadsheets because nobody's going to, unless there's a key, nobody's going to know what that means later on. And these deals can go on for a while. They can pick up a year later. And if nobody knows what those colors were intended to represent, if they represent anything at all, that's problematic because someone's going to have to look at those records again. You want to remove any ambiguity from this data report. Really
needs to
consider
stand on its own.
Exactly. The other thing is consistency. We have a very precise way our patent data reports are constructed. The fields go, we have the exact fields we want. They go in a particular order. They're answered in a particular way. Status is described in a discrete way. It may sound very particular, but I'm telling you it helps a lot because paralegals all do it the same way. If one person starts, another can pick up and know exactly where that person left off. When it goes to the attorney, they're not trying to understand any individual person's flair. They're seeing the docket, the information very consistently. It makes it much faster to go through, and as you put together your patent, your summary of your findings, it makes it much easier to do.
I can see how that lack of ambiguity would be, less questions, less worries. It just seems to all go more smoothly that way.
Yeah, exactly. Exactly. And keep in mind that the patent data report can be used for other purposes. When we are finished with a diligence, sometimes we're involved with the asset transfer. We can turn that into a schedule of assets. If we're actually involved in the title update, we can use that patent data report as the basis for our title update report, which we, tweak and add a few columns. So again, format, as Andrew mentioned, consistency is important, and having something that's used over and over again will make things go faster and just make the product more accessible to the people on your team. Okay.
Awesome.
So
do you want to highlight that consistency in terms of assignment data coming up next?
Yeah, definitely. So we always review the USPTO assignment data because it's the one country where the assignment information is separate from the image file wrapper, and you can have incongruity between those two, where the applicant doesn't match what the chain of title shows for the assignment. So you might have applicant ABC, and for some reason the inventor's assigned to XYZ. Like, how did that happen? Those are things that you might flag. As Andrew mentioned, there could be encumbrances on the patent, so security interests or liens. You can't sell a patent if a bank or other entity has an ownership stake in it. And lastly, these breaks in chain of title. Now, this isn't going to happen on the foreign PTO side, but this does happen quite frequently in the USPTO. And some examples of these breaks in chain of title, I think we have on the next slide. the one on the left is illustrative. We have the inventor assigned to company A, second inventor assigns to company A, and then company B assigns to company C. So we're missing that link between companies A and B. This is a red flag and something you would definitely call out in the notes section of your patent data report, because if somebody's selling that patent, they're going to need to explain it. Buying the, whoever's responsible is going to need to explain that and provide documentation to clean that up. The example on the right is just illustrative of an effective date not making sense. Here we have the inventors assigned to company A, and then company B assigns to company C, and later company A, they said, oh, we forgot the A to B, and then they file it later. Well, did B have anything assigned to C? It's arguable, right? Based on what we see, that's a red flag. So this is a vendor report. We use this for our due diligence, and what this does, we format it so we have the current assignee. This is US PTO data. It has all the inventors, and then it allows us these assignments, 1, 2, etc. Sometimes there's 10, 15 assignments or links in the chain of title. We can go one by one and see, did the inventors assign? Like, did the chain of title go in order? Are there breaks in chain of title? Are there unreleased security interests? Also, this is much better, that it's more easy to digest than just having links, like here's a link to the USPTO assignment database. First, because somebody has to look, and that's a mess of data if anyone's had to look at it. It is not easy to filter through that. Also, the USPTO is down, in my experience, a considerable amount of time. Instead, something like this, a product that can show you chain of title very clearly, so breaks are very easy to identify. And one nice thing about this report is that you can click on any one of those cells and it takes you to the assignment itself, which is great because let's say there's a security interest. You might want to see the details of the security interest, or you see assignment from company A to B that's not been recorded in the foreign jurisdictions. Click on that assignment, maybe the schedule of foreign assets is there and has been assigned, but not yet recorded. So really helpful. Again, let the product do the work for you whenever possible.
Awesome. Let's talk about 3 common red flags that we see when it comes to doing this work: identifying issues, points of uncertainty. Let's see. Actually, so first we'll talk about red flags, and then we'll talk about the common pitfalls that these red flags can oftentimes come up with. So, so Jennifer just went into detail about breaks in the chain of title, so I don't need to go into too much detail about that. Similar with unreleased security interests, so can't sell something if it's still on lien to a bank. Something that I was unaware of until I started developing this presentation with Jennifer are things like, for example, a mismatch in priority applicant versus the applicant on a PCT request. So all of these are very kind of in the weeds sorts of ownership issues to keep an eye out for. Over to the legal side, there are things tucked away in the file history or office actions, petitions, decisions, oppositions, which are going to be important for you to flag and make sure that the client or the attorney you're working with is aware of. And then finally, as Jennifer mentioned near the beginning of the call, where there are data discrepancies. So if you've started with a disclosure schedule and based on your research, you found something else than what's listed there, that's going to be pretty important for you to flag too. Let's talk briefly about those file history items: petitions and requests, non-publication requests, terminal disclaimers. Once again, I'm going to turn to Jennifer for the details here. It's going to be a hassle for you to go to any given patent and trademark office website to look up the history of prosecution for a patent. Best practices would be if a vendor can link you directly to that file history from the report you're generating, or perhaps from a family tree, making it easier for you on that asset by asset review. You click, you go and look for the references of interest. If they're included, highlight them. If not, then you move on. So Jennifer, can you tell us a little bit more about these specific file history items and how they impact?
Sure. In the interest of time, I'll go pretty quickly, but sometimes
Sure.
when we're doing a deep dive where we want to turn every stone, we are going to look for things like non-publication requests. This would historically be found in the image file wrapper on Patent Center. You'd look for a non-publication request. Non-publication requests are critical to identify if there's foreign filing in the family. If they filed a non-publication request and then foreign filed without rescinding that non-publication request on time, that invalidates the US patent. Not just
Hmm.
that priority patent, but if there is a related patent of that subject matter, someone thinks, oh, I made a mistake, I'm just going to refile. No, that is something a third party could come in and invalidate because that subject matter in the US is no longer available if
Hmm.
you filed a non-pub request, then foreign filed and didn't rescind as you needed to. There are certain petitions that we might look at, petitions to revive, petitions to change inventorship in case that could cause some issues with priority claims, for example, restorations of priority claim, delayed priority claim, late PCT national phase, and certain withdrawals. Now, these are exceptionally requested. This isn't something this does require a deeper dive, but if we are overturning each of those stones, we want to look at issues that have had that could compromise the integrity of the patent in any way, and those are some of them. Likewise, with PCT applications, if there's any notification of incorporation by reference, something was missing when the PCT was filed and they introduced it under the incorporation by reference provision, or the priority claim was missed, and you've had to restore the priority within that 14 months from the priority date. Keep in mind that those decisions, if there's a decision that's favorable, it doesn't apply to all countries. And so they could have pursued patents in China without the restoration of priority claim being valid. Or this level, you got unintentional restoration but not due care. That's not going to carry over to all your countries. And priority is important if there's any intervening rights or there was disclosure between the priority date and the filing date wherein that priority claim is lost, your patent is invalid because of novelty purposes.
Hmm. Very good. Very good. Let's move on to the second common pitfall, which, as we mentioned a couple of times, understanding an EP patent, which is the ability to, to protect your invention in any country that participates in, the jurisdiction of the European Patent Office. So can only be validated in designated countries. One of the problems with this is that how each one of those countries treats that validation differs from country to country. Some publish translations, some don't, some assign a new number to a publication. So this can be really tough to tease out those details and understand each one of those. So best practices, getting a good understanding both of the legal status of EP patents, EP grants, and then gathering a summary of what those validations might entail could be useful as well. So, Jennifer, I know we are running a little bit short on time. Are there, any kind of specific ones of these that you want me to touch on, or should we kind of breeze
Yeah,
through them? Or yeah,
we'll breeze through them.
okay.
If you're familiar with patents, foreign patents, you're familiar with the EP register. The way to tease out these validations manually is to go to legal status. You can see all of the countries that have been designated. Keep in mind that if something says lapsed, it is lapsed. The date will tell you if it was validated and subsequently lapsed or if it never was validated at all. Absence of any information should not be construed as being active or validated. Further investigation is required.
Mm.
In the legal status tab, if you go all the way to the bottom, it gives you legal events that have happened. It gives you the country code, it gives you the date of the event, and it gives you some additional information that can give you some insights as to whether or not something was validated and whether something was maintained. So I won't go through all of these examples, but these are just, if you see certain things, you know it's been validated. If you see others, you know it's not been validated. Ownership's important. Ownership after the grant of a patent is recorded before each validated offices. That is not often found in legal status for most countries, and so you would need to go to the national office itself. Clicking on the hyperlink in the legal status of the EP register will take you directly to the national PTO for that particular EP patent and give you the information on confirming status and ownership, if not otherwise available. Just want to make a note, there's also the Federated Register, and at first blush, this looks like, wow, it's on the fly information. Look at all of this that's there. The fact that they say it's on the fly, it's not necessarily current. It's when the last update came from the national office, and not all offices are part of the Federated Register. Sometimes I'll go there and you'll just get some very low-hanging fruit. These were never validated. This is last annuity paid, but I prefer legal status to the Federated Register because at first blush, it looks like, wow, this is all great, accurate on the fly information, and it's not necessarily. I wouldn't rely on it.
Just one more, I think.
Yep, and this is just a snapshot of the Federated Register. There's inconsistent terminology used, and this is some things that you can find very quickly in the pink. Other things, there's sometimes they only list the first applicant. If there's multiple applicants or patentees, there's just a lot of inconsistencies between countries here. And so I think legal status is the way to go if you cannot otherwise get the information from the vendor you're using.
All right. And for the last pitfall, we'll address those unpublished assets. As we mentioned, provisional applications, recently filed continuations, CIPs or divisionals, and those WO national phase entries, which are not going to appear in a publication-based report. So, needing to go to Patent Center, Patent Scope for every asset, in order to verify these, not always going to be an easy process for you. Family tree visualizations that visualize those unpublished assets, who make use of that data already to highlight those for you, are going to save you time. But what are some of the ways to identify these otherwise?
Certainly going into Patent Center, going into the continuity data, this will show you those unpublished provisionals. It will show you recently filed constivs, CIPs. You have to go into Patent Center, and again, I'm hoping they smooth it out. It's a bumpy ride, and you can't always get in there when you need to get in there. And this is just a snapshot from the national phase of a PCT application. Now, what's nice about Patent Scope is that, and again, this is kind of the image file wrapper for PCTs, plus they do other data now, but the national phase tab, offices report back in some instances before the case is published, and that is very useful information to have, because if you just did the search and based on the publications, you might miss out on a number of these jurisdictions.
All right, we're about to close here. So here's kind of one of our closing slides, best practices to quickly get you to that final report. Having used these tips, used many of the details that Jennifer and I have shared, we're hoping that you're going to be able to produce a report in a minimum of time and a minimum of effort as well. Just reminding you about some of the best practices that we recommend. Vendor supplied resources are very time saving for work like this. And going to get you on your way to making your attorneys and ideally your clients happy, understanding the scope of their ownership, of their legal status for portfolios of interest. So with that, we will go ahead and open it up to questions. And so over to my over to Tori from Paralegal Brief.
Thank you both for such an insightful presentation. Looks like we have time for one or two questions here. As a reminder, we understand if you need to run, just know today's session is being recorded and will be emailed to you within the next 48 hours. And of course, if we don't get to your question today, we'd like to encourage you to connect with our panelists using the channels on the screen, and they're also in the chat. Okay, so this first question comes from Terry. How are you handling the inability to do assignment searches with the PTO having locked down the assignment branch after the data breach months ago?
Yeah, that's a great question. So the U.S. assignment database, as we mentioned before, kind of the single source of truth for whoever is the current assignee, and there have been a lot of issues accessing that data. So, Jennifer, is that a resource you're familiar? Or are you familiar with the problems that Terry is mentioning here?
Yes, and there are instances not only with the USPTO data, but with other countries where you can't definitively provide a status ownership chain of title on the US side. And unknown is an important indicator in a patent data sheet. You might require the other side to provide the information if we cannot get to it, or foreign counsel. We have had luck with that assignment database that was in the slides earlier, where we could just click and get the assignments. We found that has been pretty consistently reliable, even when the USPTO has shielded that information from us. But if anything's ever unknown, don't guess. Just put it's unknown, not available, and somebody else will need to provide the information.
This next question comes from Nicole. How often do you encounter discrepancies in patent ownership, and what's your approach to resolve them?
Oh gosh, I think more frequently than you would like. Am I right, Jennifer?
Yes, it happens. I would say between 5 and 10% of the assets reviewed have some sort of ownership issue in general. Some portfolios are very clean, others are riddled with breaks in chain of title. Foreign assets not being updated because it's expensive and it's time consuming. So we often find that although the assets were assigned, they were never recorded. Huge flag, because if somebody acquires those, it's going to be a lot of time and money to clean that up. I did want to circle back on the assignment question.
Hmm.
Um, one workaround that we've done is if those U.S. cases are filed in foreign jurisdictions, including India, for example, India, Australia is another one. If you think some assets had been transferred, after filing in a foreign jurisdiction, but certainly those countries, Canada, India, and Australia, New Zealand, where they require entitlements, sometimes we've been able to find those assignments in those counterpart image file wrappers.
That's right. So besides the US, there are those few other jurisdictions that update those assignments too. So that's good. That's a good point.
Thank you both. And that is all the time that we have for today. I hope you all learned half as much as I did. Again, if we didn't get to your question today, you can connect with our panelists using the channels on the screen, and they're also in the chat. Before we go, we'd like to encourage you to participate in the survey that will pop up in your browser after the webinar. This feedback helps us to continue to produce webinars you all enjoy. Thank you to our sponsor, Mindsoft, and a special thank you to our fantastic speakers, Andrew and Jennifer, and a huge thank you to you all for attending. I'm Tori, and I hope you have a great rest of your day.
Thanks, everyone.
Thank you very much.